Just to break it down for you, a couple of days ago, things happened in the country where there was an outcry. Literally, some of those children that said to be minors been incarceration for, or behind bars, if you will, however you want to describe it, for about 60 days or so plus. And then they were arraigned in court, and there was just an outrage across the country and across board. And the president had to swoop in to say, release them as soon as possible without prejudice to the case and all of that. The Attorney General took over the case, and you know what played out. They were finally released and charges dropped and all of that. So we're looking at all of that again from a very unique angle. We're being joined in the program by Senior Advocate of Nigeria, Mr. Muiz Banire. He joins us from our Abuja studio. Mr. Banire, thank you so much for coming on the program.
My pleasure. Good evening, and thanks for having me.
Okay, let's begin by the generic outlook that people have been talking about. I've had conversations with your colleagues, some members of the inner bar, and maybe I'll start from there. I'm talking about SAN Adegborua, who we talked to, I think, a day or two ago, and he said that what the federal government did with those children was basically face saving. Those were his words. And that had been issue. They had no case, and to avoid that embarrassment, they had to swoop in quickly to make a recovery. And all of this they were just doing was window dressing. They were strong words, by the way. How would you respond to that? Maybe you break it down to us, another angle we may not be able to get.
Well, let me start by saying that I'm not in a position to actually say whether they have a case or not. That's for the court to actually determine. For the police that investigated, they ought to have their evidence before charging them to court. So, and the court is the final arbiter in such situations. So it's difficult for any lawyer to actually come to the conclusion immediately they say they have no case. All you can say is that from your perspective, maybe he has seen the proof of evidence, and from that, he has come to his own conclusion to say that, okay, this is not enough to sustain the charges before the court. Then that might make sense. But to just outrightly say that there's no case, I think is a bit unsafe.
So I also heard in my conversations as well, in my study, that these cases that has to do with treason, for instance, they are very serious cases because they carry capital punishment, according to the Criminal Code in Section 37. And so for such cases to be prosecuted, it shouldn't have come from the office of the IGP. It should have actually come from the Attorney General of the Federation, because we're talking about overthrow of government. I want you to speak to the merit of that argument, because I want us to go through the journey of this legalese as much as possible and get to a destination that all of us may be able to agree or disagree.
But that's the matter of choice, to be candid. The police can. They have lawyers there. They have their own legal department. They are empowered to prosecute. But the Attorney General, of course, reserves the right to take over at any point in time if it so deems fit. But that the police cannot, it does not make any difference at all whether it is treason or it is a lesser offense. They have the capacity to prosecute.
So are you saying by law, when it comes to treason, the police have the capacity to prosecute anybody for treason?
Certainly.
Okay.
Certainly.
Okay, let's talk about these minors. Let's now zoom into this issue of the minors. And maybe you educate us, because we're also here to learn from the legal minds like yourself as to how should this go? Because right now there's that general outrage. Perhaps the police position where they're coming from is the fact that these young boys or these minors, they committed a crime. And they should face justice, quote and unquote, permit my word, for their crime. Because, so how do you prosecute a minor under criminal justice in Nigeria? Because there are Child Protection Acts and all of this act that protects the child, and there are principles to this as much as possible. How do you proceed when it comes to criminal justice when it involves a minor? Because people are identifying that there are missteps that the prosecutors did that generated that outrage.
Well, let me start by saying that I suspect that my intervention in my column this morning in the Sun newspaper probably birthed my appearance this evening. I discussed extensively those issues. And my position is simple. In the first instance, I think technically the police is wrong to have arraigned the children or the minors, if you want to call them as such, before the regular court. Ideally, they should have been taken before the family court, who knows the appropriate thing to do with them. But strangely, this afternoon, I was accosted by one of the prosecutors after reading my intervention this morning. And shockingly, I was shown the charges before the court, the file before the court. I discovered that only 2 of them, of the over 70 suspects arraigned before the court, happened to be around 14 years old. Again, that ordinarily is not so much known to some of us. Even in my own intervention, I never knew that only 2 of them. Because from the charge sheet, which you can equally obtain from the court, it appears that comfortable majority of the suspects, about 68 of them, or 70 thereabout, are actually adults. But the mistake the police made, in my view, is in lumping the 2 other suspects that are minors with those adults in arranging them before the regular court. They ought ordinarily to have been taken before the family court. That's the first thing. Then secondly, in my reaction this morning also, I had noted the fact that ordinarily to have been taken to court within the period of 24 hours or thereabout. But again, I was shown a warrant of detention by the court for 60 days. Again, that saved the police from that embarrassment. Of course, if the court order their continuous detention, then they cannot be liable for any intransigence. So to a large extent, what are the normal way to arraign anybody that is a minor, regardless of the nature of the offense, even if it's treason, is to take such child or such minor before the family court and not the court that has been taken. Of course, the mistake of the police does not end there, in my view. We need to also escalate the situation to that of the judiciary itself. I would have expected, for example, the judge that actually had the matter to have even isolated the situation. I haven't noticed that or noted that some of them were minors. Ordinarily, you have said, step down the thing, go and isolate so that I can deal with the ones that I have the capacity to deal with, while the others are taken to the appropriate court. But that has not been done also, probably because of the inexperience of the court in family matters. And I think that's another aspect of it. But the truth of the matter, in my view, however, is that I can see a progression in that the condemnation has brought about appropriate reaction from the police as an institution. It gladdened my heart. In fact, that was why I had to write on that subject this morning, that the Inspector General of Police had to convene immediately beyond the probe of who is wrong somewhere. I will not even outrightly condemn any of the officials that are wrong, particularly the legal department. Nobody knows the entire law. I'm sure lessons have been learned now. The good news, however, is that quite unusually, the Inspector General of Police, understandably, has now convened a workshop to enhance the capacity of both lawyers and investigators on how to handle minors. And I think this is very interesting development.
Mr. Banire, it's surprising. The police has a legal department. It's almost it's inexcusable. The police has an entire legal department. I'm looking here at the charge sheet. Minors are anybody, any person below 18. Correct me if I'm wrong, but to the best of our knowledge, I'm seeing loads of people here. Inspector General of Police versus all of these people. I'm seeing 15, 17. I mean, there are almost 30 of them, not 2. Maybe just 2 are 14 years old. So if we're talking about isolation, there was a clear case. You could see that these were children, at least from our own layman's look. I'm not a doctor, but just looking at them, you can see they are children. Yeah. We also have a legal document, the facts showing that these are minors. Are you telling me the police, this is basic?
Well, so like I said to you, once they are lawyers, or once they are minors, they cannot be taken before the regular court.
Yes.
Certainly it has to go before the family court. That's not disputable. But again, let me just hide behind the reality that, look, nobody knows all the laws in the world. Not even judges knows all the laws. Not all lawyers know all the laws. So let me just pardon their ignorance in that respect. But like I said to you, it's something that they ought to have known. But we have all seen that they do not know. And I believe that they have learned their lesson. That's why probably they are now convening that emergency workshop.
Mr. Banire, do you really believe that the police did not know that these were minors? You know why I'm stressing on this? We're all here to learn and have understanding. There's a difference between seeing someone and maybe assuming the person is this age or that age, different from a legal document, which is a charge sheet brought before a judge, compiled by a prosecution counsel from the police, showing the judge that these are the people I want to prosecute. Name, sex, and age. And they did not know that they were not supposed to be brought, because there's also the argument of, if they are charged for treason, is the family court the first place, or they should have been taken first to the Federal High Court, who will now say, no, you can't try them because they are children, the principles of protecting the child, their privacy and all of that, take them to all of this. I want you to speak to the entirety, but it's difficult to agree that the police did not know.
No, not that. I'm not saying that they did not know, because obviously, even if there is only one, even if there is only one there that is a minor, it's still very crucial and fundamental. But now we have more than one that are minors. To that extent, what I'm saying is that they need not even go to Federal High Court at all. In fact, if I were in their shoes, what I ordinarily would have done is to isolate those that are minors from the adult, charge the adult in the appropriate court, and take the balance who are minors to the family court. That ideally should have been the situation. And I think that's the legal error committed by the legal department of the Nigerian police.
So help us speak to some of the, I don't know, maybe we can speak to some of the substance of the case now, because they were charged for treason. Help us in law to understand how a minor can be found culpable when it comes to treason, which perhaps is a possibility, because we're all learning the law now. In terms of when you talk about action and intent and omission, to what extent can the law say, no, this is beyond just what a child can do, we need to take this up as far as it gets?
Well, the position of the law, particularly Sharia, is that such a side or minor is presumed not to have such intention. It now becomes an Herculean task for the prosecutor to establish that the minor actually had the intention at the time of the commission of the alleged offense. So the presumption is in favor of the minor as far as the law is concerned. So the rest or the burden rests on the prosecutor to establish if they have such evidence. That's the position of the law.
Okay. So let's also speak to so before I forget, let me ask this particular question. From what you have said, and the outcry and the outrage and the intervention of the president and the AGF, don't you think the police owe these children an apology? Or what do you think going forward?
Well, my view of it is a bit different, because honestly speaking, you see, like this mad rush that we all do in condemning everything. If you look at the situation, I witnessed, you see, we must at every point in time try to categorize situation. When I say categorize situation, there was a protest. Some of us, including myself, were all in support of the protest. But protest is different from criminality. If you commit crime in the process, then you are a criminal. Then you will be tried appropriately. So that distinction we must first draw. Now, the second aspect of it is that, for example, during that period, you realize, I remember in Kano, for example, one man, a proprietor of a pharmacy, shouting that his entire shop were looted and so on and so forth. So, to that extent, if the police have their evidence, honestly speaking, I do not even share the position of the presidency and by extension the federal government in just leaving all of them to go home as if nothing had happened. Ideally, you should have been able to isolate them, do the proper thing. Those who are able to establish, because we are not setting a good precedent. In fact, it's a very dangerous one that we are turning them into heroes. And this is an invitation to further chaos in the nearest future. So we need at a point in time to actually, even you need not respond in a manner that we are not able to evaluate the situation properly. For example, it's possible that some of the adults, the police even have enough evidence to prosecute them successfully. Immediately, the Attorney General's office takes over, the evidence will be evaluated, and those that they know are culpable and they are likely to be able to establish the offenses against them, those one ought to have been arraigned properly. While the others that they do not have or they have weak evidence can be set free, even where there is a largesse in terms of an amnesty to say, okay, these are minors, go home. I will still expect at certain stage of the process that they will be spoken to, they will be addressed appropriately on the need not to get themselves involved in that anything that tends toward criminality in the nearest future. Otherwise, we'll be setting a very dangerous precedent for ourselves on one hand. On the other hand, again, we might unwittingly be demoralizing even those policemen that have summoned up the courage during the process to prevent criminality. So we have to always, at every point in time, try to balance all these issues before we just react rashly. I don't believe that the process that has gone at all levels, judiciary, executive, the police, is such that one can actually celebrate at all. The way and manner that we are all carrying out and making errors of them, even dashing them things, we are just only baking another eventuality that probably will consume all of us in the nearest future. I would have, like I said earlier, prefer the situation where a proper evaluation is done, those that are culpable, separated, charged appropriately, those that are not, or those that you want to even extend amnesty to, need to be spoken to. They need to be cautioned. They need to be warned against future occurrences so that all of us can be collectively safe and also at the same time not getting this security official demoralized. That is my own perspective of it.
Mr. Banire, because the big issue over their head is the fact that hanging treason charges. I think the charge was the fact that they hoisted, that they flew the Russian flag and they were calling for a takeover and all of that. Hanging these charges on these children was perhaps what caused all of this confusion, and the optics not looking good for the government. And the president had to act quickly to save the country of that embarrassment, because the international community is watching and how you prosecute these children and keeping them for that long at the end of the day. But another leg to it, which I would like you to speak to, which you will, what you would like to see. The IGP himself has said, every officer, no matter your rank, who has been involved in this particular case with the children, because primarily the Child Rights Act talks about the treatment of children. Every officer that has been involved has to give an account of what played out. We should expect maybe some reprimand, some sanction, perhaps heads to roll and someone to fall on their sword. What do you expect from such investigation?
Well, like you rightly said, I will expect that the barriers will some reprimand. For example, if you serve those, whether minor or adult, you must not serve them. If there is evidence that they were served, for example, or they were maltreated in one form or the other, of course, those officers must be responsible. They must account. So I believe that the investigation, whatever the investigation reveals, the IGP must action it in order to serve as a deterrent to others. So that even the fact that somebody is a suspect and is in a cell does not necessarily mean you must maltreat the person. You must give the person all, apart from the necessary safeguard, you must give him all the comfort that he deserves within that person, because he's presumed to still be innocent of any allegation that you have put across. So I equally expect some reprimand in that respect. But beyond reprimand, like I said to you, the only thing that gladdens my own heart is the fact that that gap has been noticed and something is being done in terms of enhancing the capacity. Because gone were those days that what we find out, particularly from the police, is grandstanding. We have done it. We know what we are doing. Nobody can talk to us. But now they have seen that they have learned their lesson and they are struggling and striving to correct it. And that is the way all public officers must behave. You can't know everything. There are times that there are missteps. When such missteps occurs, there must be remedy. They must be remedied appropriately through the action of other officers within that precinct.
Mr. Banire, it's interesting. I like your perspective in educating us and looking at all sides as much as possible, but I'm smiling because even the police will tell you that ignorance is not an excuse in the law. And this particular one is just making me remember that particular phrase. But we're going to take a quick break. When we come back, there are others that are still in detention regarding the End Bad Governance protest, and people are calling for their release as well. Since that magnanimity has gone to those children as well as the other adults that are with them, why don't you spread the love? I want you to speak to that and also address the issue, the bigger issue of impact of this, which has to do with whether or not the actions of government is shrinking the civic space. I'd like your intervention as well. So we'll take this quick break. When we come back, Mr. Banire is still with us in our Abuja studios. Join us again. All right, welcome back. We're still with the senior advocate of Nigeria, Mr. Muiz Banire, who is bringing all sides to the perspective, bringing perspective to all sides of this particular conversation when it has to do with the incarceration or the arrest and detention of those children for 60 days and eventual intervention of the president to ensure they are quickly released and sent to their parents. And of course, the vice president had received them. So we're looking at every part of the law as to whether or not, when it comes to criminal justice, whether they can be tried in regular court. And they said clearly no, of course. And he talked about the issue of the argument as to when it has to do with treason, whether it's a federal high court case or it has to be with the family court, is dismantled that to say as long as children are involved, a few things falls as pack of cards. But he's here. Mr. Banire, thank you so much for staying with us. Let's expand it even. Let's one more thing or two more questions that has to do with this issue before I take you on other issues as well. And some people are saying, look, if that magnanimity was because of the children given across to other adults, there were about 119 of them, because not all of them were children or minors. There were others that were not minors. They have also been freed by the case has been struck out. Shouldn't that be done to everybody in the spirit of, I think you call it amnesty? But these people were protesting against bad governance, but the charges were that they were committing treason because of maybe raising flags or calling for the president to be removed by the military and all of that.
Well, if that is the general allegation, I'm sure that there are other issues that are behind it. For example, when we had our portion or share of the misadventure during the NSAS process in Lagos, we lost so many things, so many public property, including our courts, a lot of historical documents, everything got lost during that period. I think the first thing we must always do is to draw, like I said earlier, distinction between criminality and protest. I am for protest 1,000,000%. I support protest. In fact, any government where there is no problem must be uncomfortable. People have fundamental right to protest any day. In fact, for me, by extension, like the court have said, the police equally have a duty to protect the protesters equally. They must protest them. But however, no protester has a right, for example, to destroy public or private property nor attack any other innocent citizen. At that point, you have crossed the red line and you must pay for it. So if you go beyond protest into destruction of public or private properties, then that is criminality. I will not subscribe to the view that such people must just be let go, because we'll be setting, like I said, a dangerous precedent and emboldening them against the future in one respect. And on the other side, we equally, unwittingly, be demoralizing the security official, the police. It happened after the exercise. Ask the people in Lagos, for a long time, the policemen lacked the courage to even open their own divisional offices. It was that bad. Whenever they were going home during those periods, they would have to quickly change their dresses. So this is not good for the safety of all of us. So for me, it's a question of continuous balancing. If you commit criminality in the process of course, you must be charged and prosecuted. But if it's just simply protest, no, that one is not acceptable to anybody. And I believe that it must not even be acceptable to the same government and the operator, because they themselves, one day they will become protesters, and they have been protesters before.
Let me piggyback.
That's the reality.
Let me piggyback on the part where you talked about the issue of protest. We can separate criminality clearly from protest. I think the average person knows where to draw the line. So that is very clear to everybody. But we've seen funny things happen. So piggyback on what you said about the right to protest. Civil society organization, media, we've had conversations, and it feels like under this government, it appears that the civic space continues to shrink. People don't feel easily emboldened, because if you call people to go and protest now, that I don't want to be arrested, police permit, and all of those things. Is this good for democracy?
It is certainly not good for democracy. It's not good at all. I will never subscribe or support that. The space must be open. In fact, it must be widened. People must be able to hear their opinion. It's when you are unable to hear your own view that you go into criminality sometimes. So for me, it needs to even be widened. So I'm not in support at all. Civil society, in this regard, I expect, which we have done, even the Nigerian Bar Association did the same thing, must continuously have their own lawyers on ground. We must force them to charge anybody that they believe as anybody that an allegation has been made against to court. And the civil society, through their lawyers, there are so many lawyers that are into these pro bono services now. And I'm sure they'll be available. We must not allow it to shrink at all. We must not. Otherwise, we are all endangered collectively.
So I have mentioned civil society, I've mentioned media and a couple of other people. From where you sit, what do you see as far as the issue of civic space is concerned? Are you comfortable? So it's not like one is making an allegation. Where you sit, and I know you served in government, you know people, you're a strong man, one of the strong men we have in politics. Do you see, what do you see? What do you see from where you sit?
Well, what I see is a situation where messages are being delivered that by people that were not sent. Because our president, I seem to have an idea of who he is. We've all engaged in protests together at several points in time. But you know the way and manner that our security officials react to things at times. You start wondering where their allegiance lies. Is it to the federal government of Nigeria or the federation, or to the personality of the head of an agency or head of a government? Again, that is where the challenge is. At times, they are not even sent what they are doing. For my position is simply that I'm uncomfortable with the state of the civic society's civil rights generally in the country. It needs to be, yes, it needs to be widened. Honestly, we must allow people, because a true leader must continuously see criticism of his administration as a feedback mechanism. When you get such feedback, you evaluate and do the needful. And even if you are not doing it, you see convinced of your position. For example, take the issue of tax, of the VAT that is ongoing, the raging debate now. The federal government is saying, no, we are convinced of our position. The duty that the federal government will now have is to continuously enlighten and educate those who do not share their position. That is the duty of government. It's not to start arresting people indiscriminately and throwing them into jail all over the whole place. No, it must not be. That is not leadership in my view.
Because there's a lot of failures to that extent in certain parts as far as this democracy is concerned. So people are like, because things are really rough and tough for a lot of people. The government recognizes that. That's why we can say it time and again. But you've mentioned something as though you looked through my notes, which was my next line of question. This issue of tax reform that has been rejected by northern governors, as well as NEC is saying, look, federal government, you need to hold your fire on this particular one. Because the core of the conversation is the fact that the revenue or derivation model has actually changed such that the places where goods are produced will now earn more. Perhaps the thinking of the federal government, in my understanding, is to make states more enterprising so that they can make more money for themselves, more like implicit fiscal federalism or federalism through the back door. What's your interpretation of what is playing out? Because some people are saying it's now in the murky waters of politics. Should we throw the baby on the bathwater, and what will be your intervention?
Well, interestingly, I have a completely different view of the situation. My very strong view, legally and constitutionally, is that even VAT does not even belong to the federal government at all, or the federation. VAT is under the residual list, which belong to the respective state. The state must be allowed to collect their own VAT. That is the position of the law as I understand it. What even the federal government is doing is window dressing. Let's call a spade a spade. But I'm sure that it's just diplomacy that is all that is going on, if you like, call it politics. Because otherwise, this situation, we are going to return the right. This thing was hijacked during the military administration and was a carryover of that military regime. So it's not something that we must, as the Constitution stands today, I cannot find it neither under the exclusive list nor under the concurrent list. And any matter under the residual, we all know that it's a matter for the state. And it's more or less technically a consumption tax that belongs to the state. So the argument, the way I understand it, I might be wrong, but of the federal government might then be that if it is a consumption tax, then you give the state where such goods were consumed preponderance of what had been consumed in their own trade, what accrued from their state. I'm sure that is their own argument, but again, I call it window dressing. The idea thing would have been enforce the constitutional provision, let the state go and collect its own VAT. Finish.
Well, the northern governors are just...
You know, if you remember, sorry to cut in, you remember again that when the current minister for FEC was the governor of Rivers.
Yeah, I remember.
You know, he went to court on the same issue and won. And the matter is still at the Court of Appeal. In fact, there is another matter that was decided that is at the Supreme Court, all in favor of the fact that the matter, the VAT, is exclusively within the province of the states. And that is a validation
Mr. Banire, just for context, so what I know is the fact that it's now even beyond whether federal government is collecting. Federal government collects 15%. You are saying they shouldn't collect anything. It's now the question of where the goods is produced versus where the goods are consumed or the services are consumed, which is what that argument is really all about. But if we must move on from that, I said I'm going to have your take on a couple of other issues. Let's talk about your arm of government or your sector, if you allow me to use that word, the judiciary. The judiciary has been on trial for a long time, time and again, depending on what plays out. And unfortunately, it has to do with when it comes to political issues, that's when the true test of the integrity of the judiciary is being put to the fore. And everybody has an interpretation to what they perceive of the judiciary. But let's give the common one that we've seen. I'm saying this because we have a new CJN who we understand is a no-nonsense person. But the level of intervention in terms of immediacy and urgency, I don't know whether I've seen it. When it comes to conflicting court judgment, what do we do to correct this anomaly as soon as possible as a nation? Because this looks like basics in law. You take it, issues of concurrent jurisdiction, and different courts are hearing it, but they are on concurrent jurisdiction. Sometimes they don't even have jurisdiction at all. They still hear it and go around it without touching the substantive case, and it has to be set aside for any progress to be made. We're seeing what's happening with the politics of Rivers. It happened in Edo, it happened in Kano.
Well, honestly speaking, I share your concern on this subject, conflicting judgment. The first thing that must happen is that we must agree that there must be sanction for misconduct or misbehavior. That is non-negotiable. That has not been potent enough in my very strong view. Secondly, technology has come to stay. This thing can be easily resolved through technology. Even, let's say, Court of Appeal, where we have several divisions. There is basic technology today that when the government is given in a place like Taraba, in a place like Sokoto, you can easily download. And any judge adjudicating on similar matter can easily view it in Lagos. This is a very simple thing to do. Again, the reality is that, like you rightly observed that, and I made the intervention in my last column to say that it seems that people are even choosing their own jurisdiction now, politicians particularly, their preferred jurisdiction. They say, this is my own enclave. And once I am there, I'm safe. I get the desired judgment that I want. This one will go to his own enclave too and do the same thing. Again, it's a matter that I believe calls for urgency. And I want to believe that the CJN is going to be taking it seriously. I understand there is a probe going on now. But my expectation is that we must make scapegoats of some people. We must sanction them. Except we start doing that and people see that the National Judicial Council is serious. I had the privilege of serving in the National Judicial Council for 4 years. And I know that what we actually need is making an example of some of these people that are conducting the affair recklessly in the judiciary. Because even some law schools today will tell you easily what the jurisdiction of this court is as opposed to this court. A judge cannot pretend, even where some lawyers disguise it. I have advocated in that my intervention, for example, to say it's not only the judges that must be condemned, even lawyers, particularly a senior lawyer that engages in all these kind of antics, must be dealt with decisively. We all need to be deterred from misconduct and misbehavior, impropriety. This is the last hope, and it must remain so. It is dangerous for us, for the judiciary to become a lost hope, as described by one of our colleagues. If it is a lost hope, the only thing that you see is simply an invitation to anarchy in the land. And that is the end of the road for the society. So I agree with you entirely that something needs to be done. I'm aware that steps have been taken in recent past, but they are not enough because there has not been effective sanction. We need sanction. We need scapegoat to be made of some of these people. That is when people will be deterred. from being reckless in the way and manner they conduct their affairs, particularly when it comes to the administration of justice.
Mr. Banire, the reason why some of us are shouting at the top of our voice on this issue, because we know that every sector, every arm has very good people and very terrible people. And when these mischievous elements are doing these things, it just smears on everybody else like everybody is the same. So these people must be made a scapegoat, which brings me to questions that are related to insulating the judiciary itself. We must commend the federal government for increasing their, I think, their salaries now, judicial officers by 300%.
Correct.
300%.
Correct.
But we've also seen leaders, governors and leaders building houses for judges. We've seen the FCT minister, when he was governor, he did that. I've particularly gone into one of those houses of those judges, I think one of the Aguma estates, where you have to, it's state of the art, literally. I can tell you that I went in, I saw that literally you just have to come in with your clothes. Everything is there, television, furniture, everything is inside. So I saw it for myself, state of the art, swimming pool, everything. But some people are saying that this could compromise the judiciary. That's the allusion. On the other hand, they say, oh, these guys, or these leaders are saying, look, we cannot just allow these judges to be put in a state where they are tempted to, do the wrong thing. So the little we can do is to contribute to their welfare. Others are saying that will compromise them. So how do we draw this line between executive support and intervention as against insulating them against to the extent of avoiding, allowing them to be caught up in this web or being corrupted by any means? I'm almost starting because I'm trying to look for a way around it.
Well, there is a simple solution. Since I was a constitutional law student, decades ago, we've been taught about the independence of the judiciary. You can never have independence of the judiciary without financial autonomy. For me, I believe the executive are always using that to harass, in my view, the judiciary. The reality of the matter is that judges and judges' houses, judges' vehicles, their medical, everything ought to be done by the administration of the judiciary itself, not any other party like the executive. But what they are now doing is to hold on tight to this so that they can continuously use this as a bait for the judicial officers. It is very wrong, in my view. It is condemnable. Let the fund of the judiciary be released totally to the judiciary to build houses for his own judges, to buy vehicles for his judges, to take care of the welfare of his judges, and not for the executive to start doing that. How many times have you seen the celebration of the vehicles of cabinet members? Have you ever witnessed in any state that these are vehicles bought for commissioners, the governor is launching it and they're celebrating it? It's only the judiciary. It's only the judiciary that you will find that happening. So, and for me, I believe that it is very wrong. It has the tendency, you are all human. Like you rightly put it, when you are now seeing it as a favor, that somebody is doing you a favor, then there's a problem with the administration of justice. All right, Mr.
Banire, I must thank you so much for taking on a lot of the issues, because we had to move from one point to the other, and you handled it properly. Thank you so much. Mr. Muiz Banire is a senior advocate of Nigeria, coming to talk about the issue of minors as well as other issues within the judicial arm of government. Thank you, sir.
Yeah, my pleasure.